I like your t-shirt.
Thank you. You both got it for me.
Yeah.
Andrew, you were meeting with the 3O class, which may or may not be just me. I don't know where Cole went, but we typically meet in the day.
Gotcha.
So you know, because I walked by and I was like,
Is this,
So
you
there's
guys
stuff
get
in
me in
here.
here? You're all meeting in the
all-
same room. You're all in the same room because you can only do one of you at the same time. So they're just gonna review their model answers while you guys go over yours.
Okay. Never
So you
mind.
can just stay here. Come on in.
I feel like I'm getting fatter. But I noticed
okay.
Okay. So I'm gonna, since we're combined, I'm gonna run through the 3L essay first so that you can hopefully get out of here.
Can I, and I don't know, Cole, how you feel about it, but this con law one, we've already done like 6 times. We've gotten that question like a bunch of times, but I know the other two, let's see, like the one with the ethical violations and then the one about malicious prosecution.
I like that one the best.
Yeah,
We can go over that.
Right, so question, well,
it says question 1.
you're talking about question 2, I think, the ethical violations. You're
No,
talking about the.
Yeah, it's also
Patty.
Lego's question too.
Yeah.
Okay,
Okay.
well, so, been trying, it's been a few weeks since I've been here, and the last time I think was kind of a disaster, so I don't really, trying to figure out how to best be helpful. So I guess, you've taken that essay, you've seen the model answer, how much, because you said this is the one that you want to go over. So would you say that you're bothered, but or confused or want to go over the substance of the essay, or you still feel that some of the nuts and bolts of writing a bar answer are lacking? So what I mean is that if you had like the rule, like if you had the actual rule, the 12b6 in front of you, would you feel confident to write this essay cold?
With the rule in front?
Yeah, with the rule in front of you. So I guess the one thing that I want to say, because I think it's universal. So I was talking about CREAC last week, And I still really believe that CREAC is and IRAC are not incompatible with one another, but since it seems to have really confused people, I do notice that all of the model answers that you've gotten really adhere to IRAC. I haven't seen any that use CREAC. Now, like I said, I don't think they're as different as you think that they are, but in terms of the way that they're set up, these model answers, I think, even did a better job because a lot of the paragraphs, it separated each by paragraph. Like there was one paragraph where it talked about the issue, one paragraph where it stated the rule, one paragraph where it applied it, and one paragraph where there was a conclusion. So, I guess the one thing that I would want to talk about is, so let's look at the first model answer on page 4.
Mm-hmm.
So point out where in, I don't know if this is going to be helpful, but point out where in the model essay the rule is for the first question about the motion to dismiss.
A motion to dis-
Third,
end of the third sentence.
of the second paragraph.
Yeah. So so a lot of this, if you the first part of this model answer, what it does is it pulls out the facts that are related to that issue. So in order to frame the issue, and it's not a mystery, but in order to frame the issue, so if you want to talk about the motion to dismiss, you have to at least set up what the lawsuit was, which is where it starts, that Patty instituted a suit via her lawyer, because if we're not in court, what motion are we dismissing? So that's also something I was trying to talk about last week, which I again don't think worked very well. But just think about, like, you know, where do you start? I mean, you're starting in court. So it lays out the issue by picking out which facts are the most important for that issue. And in a lot of ways, it's self-evident. You know that you're in court. You know what the lawsuit was about. You know how the accident happened. But you want to be picking out that that's what's important versus the conversation that Patty had with Art in order to set up what the issue is. So it goes that way, and then this is one of those cases where I don't think there's any way around this answer unless you know the rule. I don't think this is one you can kind of like feel your way through. So what I will say is that 12b6 motions are something that you're going to see tested. Like, you don't have to know every rule, like every rule, federal civil procedure, but that's one of the ones that you're going to really see. You might also see the summary judgment standard get tested. Like, that's one that you're going to see. So the 12b6 rule is that a motion to dismiss based on a failure to state a cause of action upon which relief can be granted is a 12b6 motion in federal court. Now, that's good to know. Make sure that you're in federal court. Like, if you're going to be citing the federal rules of civil procedure, make sure that you're in federal court, number one. And number two, it's more important to get the substance of the rule right than the number of the rule right. And what I mean by that is that you might accidentally box yourself into a corner because you could probably get full points by not mentioning the number of the rule. But if you put the number of the rule in and you get it wrong, then you're going to be like losing points. So make sure you know, like, if you're going to cite the rule by its number, make sure that you know. So a motion can be filed as a preliminary motion to the filing of a complaint or contained within an answer. Now, that is already, that's I don't know if you want to call it a second rule statement, but that's another fact about that rule that is, by rule, I mean 12b6, not rule in terms of the essay. That's another fact about the rule. That's another aspect of the rule that's essential to answer the question. And the reason why that is because procedurally, you would expect an answer to follow a complaint. So there are certain motions that can be filed as your preliminary motion before you file an answer, and that's something that, again, that those are just things that are necessary in order to get the in order to set out the rule. And you can frame it in a couple of different ways, because you could say, for example, that a complaint is ordinarily followed by an answer, but the rules allow certain preliminary motions before filing an answer, like however you're going to do it. And it seems like you're doing a pretty good job of getting the rules memorized. So if that's the approach that is going to be most helpful, then I mean this is the rule. And then as we go on, this whole paragraph really goes through all the elements of the rule. So that it's a preliminary motion that can be filed before the answer, that what it says is that, okay, so what is a motion to dismiss? Can someone put it in different words? Like what do you have to show in order to prevail on the motion to dismiss?
Basically, you say on the face of the document, they don't have a cause of action.
Right, so if everything that taking everything in the complaint as true, it doesn't amount to what they're saying, that what they're suing you for the cause of action. So it would sort of be like, Andrew is sitting in this classroom, Andrew is trying to do better than he did last week, therefore the court should grant damages to the class for assault. Well, okay, like what? Like, like all those, yeah, what?
You need a little more work on.
Exactly, well, exactly. So you need the facts that you amount to need to amount to the cause of action. Now, they don't have to be you don't have to know every fact about the claim, because that's why you have discovery, but you need to have sufficient facts to meet all the elements of the claim. And then the other thing that I'll just throw out, and I don't really think it makes a difference if you mention it in this answer, because the model answer doesn't really talk about it, but you can't have conclusory allegations, which is the Iqbal and Twombly thing. So if the cause of action is is negligence, you can't just say Andrew had a duty, Andrew breached the duty, plaintiff was injured.
No,
Therefore, therefore there's a cause of action. So if you know the standard for the motion to dismiss, you will lay that out, and then let's apply the case to the rule. So we have the rule, right? That even if all the things that you say are true, there's no claim. There's nothing there. So talk me through that. What facts? Is there a claim here or not?
No.
And why?
Well, based off of, because he already said, the attorney already said negligence wasn't gonna work. And they discussed that later because it doesn't appear that the conduct of, what's his name, David, fell below the standard of care. However, as far as an ultra hazardous activity, while the transportation of the gas would be considered an ultra hazardous activity, that's not actually, the transportation of the gas didn't have anything to do with the accident, which was the oil slick in the roadway, which had nothing to do with anything that David was doing except driving.
So there's no
Okay.
approximate cause.
So right, there's no causation there. He wasn't negligent. It's just there was an oil slick. So, and even if he was, the ultra hazardous activity is not what injured her. What injured her was this traffic delay.
So that
So that's like
is,
strict liability.
so that is excellent. That's really the way that's how to construct the answer. But what I want to point out is the same way you can't have conclusory allegations in a complaint. You also can't really have conclusory allegations in your bar answer. So what I mean by that is that you might see this really clearly, and you might in haste write something like, a motion to dismiss based on Rule B6 is if all the points in the complaint are true, there's still not a cause of action. That's not true here, therefore there's no cause of action. You need to go through and point out, just the way you did, why there's no cause of action. So in order to do that, you need to know firstly the elements of the cause of action. So the elements of negligence, and in this case, the elements of strict liability. And you also rightfully, you went basically to proximate cause, you didn't spend 3 hours going through the elements that don't have any bearing on the claim. You went right to proximate cause. So that's why I think that what Anise said is kind of a good encapsulation of what the correct answer would be. And actually, I don't know if I'm right or wrong, but it might in some cases be easier to speak through it than it is to write it out. So if you practice talking through it, because that was very good. So if you practice talking through it, it might in some cases be easier than writing it out. So any questions on that part so far, or where because where can I help you? You said you wanted to go over this question, so.
Well, the reason I said it is because we were under the impression there was something having to do with professional responsibility. That's why I don't know why we got this. But as far as malicious prosecution, from our standpoint, I mean, this is not, obviously we need to know this, so it's fine. But as far as where a professional responsibility element would come in on this essay, which would be, I guess, the fact that the lawyer
I think what it is how do you structure an essay that's obviously a crossover to some extent, considering that it has the professional responsibility elements, but also the civ pro elements as well.
So the way
I think it's just basically follow the question, right? How they structure it, answer. I mean, question 1 is obviously the civ pro aspect, and then question 2 is the malicious prosecution. So I think you just separate it that way. But I think initially
it doesn't ask for the ethical violation here, though. It asks for the malicious
malicious prosecution is the ethical violation.
Right.
So
the way that I would go about that, and I saw that too, by the way. But the way that I would go about it is, you never want to assume in the bar answer that there's a shortcut. No, because that would be a violation of professional ethics, and I'm done. The first thing you need to do is go through the elements of the malicious prosecution claim. So this is the rule for malicious prosecution. This is what the suit would look like, and this is why it's valid or not valid. And then the next thing, in a separate paragraph, you would say, but aside from the viability of the suit, the California rules of professional responsibility say blah, 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 and therefore bringing a frivolous suit would be a violation of the ethics of a lawyer. So I would do it where you discuss the meat of the claim first and then discuss the ethical question secondarily. I don't really know if this was a perfect, like if this was supposed to be an ethics question or not, because I saw that too, and that was kind of the first thing that I saw. But I guess as a rule of thumb, ethics is going to be a part of one of the essays.
Yeah.
So don't invent it where it's not there, which is sometimes hard to do. But if you see it, it's there. I mean, it's there for you to catch.
They typically, and I'm sure they could do it from a broad standpoint, like, you know, has Alan done anything wrong here? In which case you could talk about everything under the sun, but it's typically like, what are the ethical violations, right?
Yeah, so usually it'll be part of the prompt, and yeah, to be honest, it will usually be part of a broader prompt. So it would be something like, discuss the potential claims that the attorney has, and be sure to discuss any ethical considerations that would arise in picking out a claim. And typically, in an essay that is pointing you towards an ethical question, it's going to want you to do like some of the choosing. And so that's why in the example that I gave, it was like, well, discuss the potential claims, because it wants to in some way mimic what you would have to do as a lawyer, because like more often than not, like someone's not going to come into your office and say, I'm an attorney, this is what I did, like, am I screwing up here? Like more often, you're gonna have a client that presents a problem, you have to identify what claim the client has from the problem that they have, and you have to do that within the bounds of ethics. And that's one of the core skills of being a lawyer. Like, people take their problems to you and you solve them without violating the rules of professional responsibility, which is
Creating new problems.
which is harder than it sounds sometimes.
Sounds hard to me.
So anything else about that question?
No, I think you covered it. I mean, mostly it was just the determining whether or not it was an actual professional responsibility essay or not. That's mainly what I was kind of struggling with in terms of formatting and going from there. I went off the call to question and structure in the essay and just kind of separated as like I was talking about with civil procedure being first and then professional responsibility being next. But yeah, for the future, definitely keep in mind what you said about just basically going through the elements and not necessarily concluding in the manner that you were talking about, but just kind of like assuming, I mean, and this is for anything, I mean, assume your audience knows nothing, and you just kind of lay it out all for them in the most simplistic manner as possible.
Exactly, because you will, like, probably on some of the ethical questions, it might be like a serious red flag, like something that's obviously an ethical violation, like how can you miss it? But in order to get full points on the question, it might be necessary for you to discuss. So I don't know if this would be on the bar, but the lawyer discovers something through an accidental disclosure of discovery. You'd still want to talk through how that affects the case, even though there's an ethical component to it. And that's what I meant by not taking a shortcut out of the discussion and just saying, well, that's an ethical violation, so that would be wrong, and no one would ever do that. Because if they put something in there, it's because they want you to discuss the, like, in this case, the malicious prosecution aspect. And then, just, that's another one where, and I'm probably gonna say this a lot, but I don't know that there's much of a way around this other than knowing the rule. But malicious prosecution is probably something that you could feel your way through more easily than like a motion to dismiss, because you know what malicious means, you know what prosecution means, and you could kind of put together a rule on the fly if you had to, more so than another type of question. I know that everyone is capable of reading the model answers, which is why I'm trying to bring something in other than just like, let's all read the answers together, and that's the right answer. So I don't wanna race through things. Oh, but actually I really should mention, the same way Rule 12b-6 is something that you're going to see mentioned, Rule 11 is something that you're going to see. It's probably something that's going to be tested. When I took Civ Pro 2, for some reason, we always went back to Rule 11, like whatever we were doing, my professor would bring up Rule 11, and I think it's because he sat on an ethical commit, like one of those committee that writes the ethics rules. So just be aware that in addition to anything within the bounds of professional responsibility, there's actually in the rules of civil procedure built in that you're bringing a claim in good faith, and that you can file a Rule 11 notice against the other party, which is, hey, you've brought this claim in bad faith, and we're going to go after you for sanctions unless you withdraw the claim. And then the sanctions, of course, end up being against the attorney and not the client for a Rule 11 violation. And I've seen it happen. I've seen it happen. So Rule 11 is something to recognize that it might be tested. And also, again, even if you didn't know the rule by number, it would be worthwhile to write about the fact that when an attorney signs a pleading, they are taking some responsibility for the facts in the pleading. And I don't think this is something that you would ever see on a law school question, but do you know what a verified pleading is? So a verified pleading is it's a complaint, just like any other complaint, but when the attorney writes the language that it's a verified pleading, what that means is the client is actually affirming, as though it was an affidavit, that everything in there was true. So you can actually get summary judgment based on verified pleadings because it's the same as an affidavit. It's evidence. Now, a normal complaint is not saying this is what happened so much as it's saying this is what I intend to prove. Yeah, this is what I'm alleging. In a verified complaint, you're saying, I swear this is what happened. And you can, you see it a lot in prisoner litigation because they don't have a lot of resources to do discovery. So when they sue the prison, they sue it through a verified pleading so that they can get to summary judgment phase. So it can't be brought out on a motion to dismiss. So that's actually, so let me talk about that for 1 second, even though I might really be, hopefully not confusing people like I did last week. But on typically the strategy of litigation is when you file a complaint, the opponent is going to come back at you with a motion to dismiss, and you're going to have to litigate the motion to dismiss before the defendant files an answer. That's just the back and forth of litigation. So one way that people do go or try to do around that is a verified pleading. And the reason why a verified pleading is going to get you around that motion to dismiss hump is because you've studied summary judgment, right? So in summary judgment, the court can only make a determination as a matter of law. It can't make a determination as a matter of fact. So once you have a verified pleading, it's a lot harder for the judge to be able to grant a motion to dismiss, because now there's a sworn allegation. So as long as it amounts to a claim, if the judge has to hear evidence from the other side, because otherwise the judge is deciding that either the complaint is true or not true, and judges can't decide facts, they decide law. I mean, outside of a bench trial, but judges don't make decisions of fact, they make decisions of law. So anyway, just something I thought I would throw in. So so any questions about this question? Okay, and do you want to go through the common law one, or?
I felt pretty good about the con law one. It's just that one in particular that
Yeah.
I had issues with, just because, I mean, it wasn't as clear as to which way I was to answer it.
Okay, so I guess for to kind of make the point that I made before, does someone want to just like talk me through the con law? Like just talk me through it. Just say, hey, this is what happened, this is what it asked, and like this is what this is how to resolve the answer question. Because I think that might be a worthwhile exercise.
Okay, so question 2, the one where the city opened up a new bus station.
Yeah,
The bulletin board.
yeah. I mean, that's the one you're saying that you don't want to go over in detail, right? So.
Yeah. Well, basically, it came down to, or I mean, for me, going on it, it requires that all free posted documents be in both English and Spanish. Of course, you could claim that this is a prior restraint, but really, it's more an expansion of your expression of speech as opposed to a limitation, because you're actually requiring that your speech is being essentially proliferated in multiple different languages, so multiple different people can read it, of course. Going back to the whole idea of content neutral versus content based, they're requiring this of all people who are wanting to post on the bulletin board, so you can't claim that, what is it? Is it intermediate scrutiny that's attached to content-based legislation? Strict scrutiny?
Content-based?
Yeah,
It's
so that's something,
Okay,
that's something
around.
that I was, and I didn't necessarily want to stop you like all the way, like in the middle, or until you got through, but the standard of review, whether it's going to be under strict scrutiny or any of the other standards, that's something that you want to have at the front of the essay, because if you start talking about the substance like that, about the content, I need to know how the court is going to evaluate it, because that's a big deal. That really affects the way the whole thing is going to go. So I think that that the model answer is good because it starts with the First Amendment, like it tells you what the source of the rule is, and then it tells you what the First Amendment embodies, that all persons have the right to free speech, and then it talks about the fact that when the government passes any law that abridges speech, it's not literally, that there are certain instances where the government is allowed to put restrictions on speech, and you don't need to discuss that explicitly in this question because that's not what it's talking about, but you do need to address it implicitly by going through the standard of review and then going through what forms the basis of whether or not the government can or can't do this. So what type of things does the court look to in order to determine whether or not a law that addresses free speech is or is not compatible with the First Amendment? Like, what things is the court going to look at?
Well, first they're going to look at where the speech is
Right, so place,
basically being expressed. So place, basically the whole time, place, and manner of the
right?
actual speech itself.
So like the mall in Washington is different than the parking lot of this law school, is different than the airport, is different than being outside an abortion clinic. Like, there's so that's one issue. So what's another thing that the court's going to look at in order to determine whether or not the government can restrict speech?
Whether they're discriminating based on the content of the speech, whether it's a blanket ban on all political signage, or it's just like, oh, we're gonna only let Republicans put their signs up because we don't like Democrats around here. And we don't want Democratic viewpoints expressed at all in this area. So
And what is the content limitation that the government is imposing in this question?
well, basically they're only allowing one side of the political aisle, I guess you'd say, a voice. They're essentially limiting public discourse to a very real extent, because both sides, both partisan groups that normally give rise to public policy are not fully included.
I don't think it's content-based at all. I mean, I think there's an argument for that it's not content-based.
So
It's content,
that, so
but it doesn't matter.
so I think that, yeah, so I guess what I was saying, and and it doesn't, you don't necessarily, so not everything is gonna get equal weight. Like when you go through the essay, not everything is gonna get equal weight, and 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 sometimes I do wanna let you like talk it out, because sometimes, as you're going, yeah, it sort of becomes clear. But yeah, so in this particular example, there's an argument that it's content neutral, right? But there's a way to frame it in a way that it isn't content neutral, because it's restricting a particular point of view. And so that's something, I mean, I think that it's open, it's open, but the way that you're going to get full points on this question is, firstly, you need to talk about it as a thing that you discuss, that whether or not it's content neutral, and then you have to point to the specific facts in the in the prompt that tell you that one way or the other. And I know it sounds like really, it probably sounds like really basic, and maybe it's not so helpful, but so many people really end up writing good answers that are just a little bit too conclusory. And the way that you weave the answer together, the way that you're going to be able to do the analysis section is you need to point out which facts are pertinent to the rule. So what facts are pertinent in this example to whether or not it's content neutral or not? What's the court, like what can you put before the court?
Whether or not it's
Whether or not it's content neutral, yeah.
I mean, first you would talk about that. That it's available for the pre-posting of documents. It requires all posted documents to be in both English and Spanish. And then refusing AAO to only or refusing their only English posting. Now I want to go back to what she was talking about with the content-based thing, and I had something pop in my head about what Drucker was talking about with not only do you have the freedom of speech, but you have the freedom of not using speech in some sense, where you have the freedom to not say something. And I guess in this particular instance, you could actually say that they have the freedom of not saying whatever they're trying to say in a specific language, I guess you would say. Although that, of course, that's not an argument that I would want to make because, this is.
No, why isn't that the direction that you want to take this question in?
Well,
in a really so I guess sometimes
it's a
my
very hard
questions
thing.
are too broad to be helpful. So you're always remembering that the purpose of this is you are supposed to be showing the bar examiner that you understand the First Amendment and the way the First Amendment applies in the usual way, in the usual circumstance. Now, every area of law has kind of its novelties that are cool to go into, and whether or not the First Amendment gives you the right to not speak. There's all sorts of different places that you could take it, but don't get a feel from the question. And the way that you're going to know that you're getting a feel from the question is if you know the rule cold. Like if you know the rule and you have the rule in front of you, then you should always be directly referencing some element of the rule. So what I mean is that after you write your rule, as you go into your analysis, every fact that you mention needs to be in your answer for the purpose of showing whether or not that element of the rule is applicable, right? So explain the First Amendment to me, real quick, 2 sentences.
Congress shall make no law.
No, don't recite it to me. Explain it to me.
Basically, Congress cannot limit your expression of speech except in special limited circumstances.
Like?
Whether it's fighting words, obscenity. There's one more that I cannot ever think of. There's a lot more actually, but
so you're right, but and this is why in certain ways what you all were telling me last week is true, that it's important to just know what the rule is. But in terms of answering a question about the First Amendment, the important part of the First Amendment for you to be aware of is not literally that the First Amendment gives you the right to free speech except in certain circumstances. It's what is the court going to look at to determine whether or not some restriction on speech does or doesn't violate the First Amendment. So when I say talk to me about the First Amendment, what does the court look at in order to determine whether or not something is violative of the First Amendment. And if you know that and you have those, those parts, that is your rule. And that is the rule that you're going to analyze by pulling facts from the prompt and showing whether or not those facts meet that rule. So, so you need to look at it from that framework that you're trying to explain whether or not a particular restriction is or isn't violative of the First Amendment. So that goes back to what I was saying before, or what I was having you go through before. First thing you need to know is, the first thing you need to write, I should say, is how is the court going to go through it? Is the court going to look at it with strict scrutiny, with moderate scrutiny, intermediate scrutiny? It's been a long time since I've done con law. The different levels of scrutiny, and you don't need to write a whole treatise about all the different levels of scrutiny. You just need to start with the scrutiny, because otherwise, how's the court looking at it? That's the place to start, the framework that the court is looking at. And then once you've addressed the framework that the court is looking at, you go through the ways that the things that the court looks at in order to determine whether something violates the First Amendment. So they look at the time and place and manner of the restriction. So that's something that the essay goes through. And then it talks about where this rule applies and the so rules have sub-rules. And in fact, for me personally, because I am taking the California bar in July, I think this book is really awesome. But of course I haven't actually taken the exam yet, so I don't know how awesome it really is. But one of the things that I think this book does really well, the essay exam writing for the California bar exam, is that it talks about how you should study for the bar in terms of levels. So that your highest level rule for the First Amendment is what type of scrutiny is it going to be, and what is the court going to look to determine whether it violates the First Amendment. And then you have a sub-level rule. Okay, so I know that the court looks at the time and place and manner of the restriction. I know that the court looks at the content. What's the rule for that? That's my sub-rule. What is the court going to look to in order to determine whether this does, because of the place that this is in, because of the type of restriction it is, does this violate the First Amendment? And the way that you will explain that in your essay is, okay, I know that it matters where the restriction applies. So what fact in my prompt tells me or talks about where this restriction applies? So that's the first thing that you should address. And usually it's not rocket science. I don't think anyone is confused about where this law applies. I mean, I don't mean to make anyone feel bad, but that's not hard. It tells you flat out what the law is, but you don't want to breeze through your answer and never make a point of explaining that this is where the rule applies and how this fits into my hierarchy of rules. And I really, I'm really going through this a little too slowly, but then you get into the area about narrowly tailored or not, and firstly, that's going to flow naturally from the type of restriction and the type of review that we have. But that's why I'm sort of talking about like rules and sub-rules, because like where there's strict scrutiny apply. And that's a rule, like that's a rule that you're gonna need to know, because when you have a First Amendment question that implicates strict scrutiny, this question, this violation is, or this law, I should say, is looked at under strict scrutiny. Strict scrutiny is, and then, so it needs to be least restrictive, narrowly tailored, like whatever it, but those are, that's where the answer is built. And in good legal writing, honestly, you should be able to pick up one of these answers and know what the First Amendment law is. That if I've never studied the First Amendment, I should be able to read your answer and learn from your answer what the First Amendment is, because you will have gone through the rule in a logical way. And by the way, that's why you read cases in law school. I mean, the court could just, your professors could just like throw laws at you, but that's not the skill of lawyering. The skill of lawyering is putting the elements together, and that's why you read cases rather than just being told, going through the California Penal Code one by one or whatever, which I think is something that people imagine law school is going to be, that you're actually going to learn the law in law school, and that would be silly. Okay, so I don't really know how I'm doing on time. So I wanted the 3 Ls to be able to get out, and I don't want to completely waste the time of the 2 Ls. So any questions? What can I go through in sort of the next 10 to 12 minutes, and then you guys are out of here? Or
Anything else?
Yeah, I don't have any questions in regards to the essay, but I recently got 2 books from Brian Gardner.
Yeah.
That's his name?
Yeah.
I was gonna ask, do you think just reading his books would considerably help my legal writing, or
so here's
is it
the,
more just kind of like writing actual legal briefs when you're an actual lawyer?
I don't think that it's going to hurt you, but I think that you need to be honest enough with yourself that if you are struggling with the techniques that your professors are telling you, you're not going to learn that from Gardner. If you want to put, if you want to make your writing more clear, then I mean that's the way to go, and that's why I talk about him. And there are some things that Gardner is going to teach you that do apply to writing a California bar essay. Like he's going to tell you to jump straight to the point and not do a lot of throat clearing. Don't spend a lot of time in your essay question at the beginning reciting the facts for no reason. Like just saying, well, so this question is about Pam and Pam delivers organs. Like don't do that. I mean, not that you are, but so that's something that you would get from Gardner. But yeah, I don't know. I'm a big fan of Brian Gardner. I don't want to sound like a broken record, but I was discouraged after the last class that I taught, because I don't know why it went so off the rails. So I guess this is a really long-winded way of saying that I think Brian Gardner is awesome. If he helps you, great. But if he's confusing you, you need to be honest enough with yourself to say, hey, this is confusing me, and let me get the nuts and bolts down.
Okay. Fair enough. Are you good, Ben?
Indeed.
All right.
Thank you.
All right.
All right.
Thank you,
Thank
sir.
you. Have a good Have a good weekend.
Thank you.
Thank you. Okay, so my next victims. Is there any particular question that you want to go through first? And, we're gonna try to go through all of them, but is there any question that you want to go through?
We don't have to do the recorded one because they give us a deed, which we have done deeds, but we haven't done recordings, so we didn't know how to answer this question. Civ Pro, we've gotten this one about 3 times as well, so maybe we could focus on the evidence question.
Okay, so that's fine. So, the recording and not recording, I know that you're saying that you haven't done it, and so I'm not gonna make a big, so with the evidence, when you're talking about question 3 with Vicky and Dean?
Yes.
Okay, cool. So, just real quick about recording deeds, that's going to be, I don't know, have you done any studying or been given any familiarity with the MBE, with the multi-state bar exam? Like, have you started doing questions for that?
We do it every exam.
Should you,
Are you
should
saying
you do-
specific to recordings though?
No, just in general.
Oh, yeah,
So
yeah.
you're familiar with the
yeah.
MBE, you're really
Yes.
immersed in it. So I'm telling you for a fact that a significant percentage of the property questions that you get on the multi-state bar exam are going to be A, sold Blackacre to B, failed to record the deed and sold Blackacre to C. Like, I'm telling you, that's going to be a significant part of the multi-state bar exam. And so what I'm really getting at is that I think that if you are at the point where you will be, where you were really ready to take the MBE, I think that essay would be a breeze, because you're just going to learn that by studying for the MBE. I don't think that's true with certain other areas, although now Civ Pro is on the MBE too, right?
Mhm.
Yeah. Okay, so let's look at Vicky and Dean. So the first question is whether the prosecution can call Whitney discuss. Now those questions are, that call is probably one of the harder ones to deal with, because where do you start? But I think that the one good thing about a call like that is that it's an invitation to spit out everything that you know that's relevant, and as you spit that out, you're going to get points. And I'm not encouraging you to not write a coherent answer, but you can be a lot more all over the place in something like this than you could be like on the common law question that we went over, where if you don't discuss it in an order that makes sense, it's not, it's just not going to make sense. So, were you all familiar with these particular rules, or was some of the confusion that you'd never seen the rule before?
There was one that we haven't covered, this California Prop 8, but other than that, I think when we recently did privileges, and one thing, this is the first time we're applying it to, one thing that I saw that I missed was that there's a distinction between actual communication, like what one said to the other spouse, and observations. I didn't realize there was that distinction.
So that goes to, so I can't help you in the sense that I can't sit here and help you learn every element of law that you don't know, and I know that you know that. I know that you're not expecting it. But what I want to point out about that is when I'm talking about these layers of the rule, so what a privilege is. What how the privilege, about the spousal privilege, how it, so the first, so the way the question, the way you go through the question is, because it doesn't specifically ask you about privilege. That's something that you have to spot on your own. So the way to answer the question is, in order for something to be admitted, blank. And Prop 8, I'm not explicitly familiar with it, but I think Prop 8 is not anything different than, I forget what rule it is in the federal rules of procedure, but it's more or less the same as the relevant evidence rule in the federal rules of evidence, that if it's relevant and it's non-privileged, it's admissible generally, unless it's subject.
The 401.
Exactly,
Okay.
exactly, unless it's subject to an exemption, or an exception. So if the question is, can the prosecution call Whitney? Firstly, I mean, what, and I hope these broad questions, but what am I gonna look at? Like, how would I know? Like, if I've got the law library to my right and I've got this question, where do I start looking?
Would privileges be a start?
Well, so what I'm getting at is the rules of evidence.
Mhm.
And
Oh,
so
I
that's
see.
why the question begins with number one, telling you, so people sometimes, I think, lose sight because they think of evidence as physical evidence, testimony is evidence, and affidavits are evidence, and then there's physical evidence too. So if you're talking about whether or not testimony can be admitted, you're talking about whether or not that particular type of evidence can be admitted. So the way that you would start is that under the rules of evidence, anything that's relevant but not privileged is admissible, unless it falls under an exception, right? So that's like the broadest rule. Now we've spotted that there's an exception here because there's a privilege. So you define what the privilege is. So that the spousal communications privilege protects confidential communications between spouses that are made, blah, blah, blah. Now, the point that you made about the observation, or like what was it, the observed versus
Oh,
what
yeah,
was
the
felt?
operation versus communication.
Yeah, so some of that, by the way, I don't think goes to I really might be wrong, and I hope I'm not confusing you, but some of that might just go to the nature of testimony anyway, because observation is a whole different beast than what was said, and we know that because we've got hearsay rules, we've got lots of rules that govern like what can be said at trial. So firstly, if you get really comfortable, and I'll be honest, I myself am not at this point, and I'm going to have to be comfortable with the California rules of evidence, but if you get like comfortable with the rules, some of that is really just going to be spotting that testimonial evidence might be different than an observation. But what I will say is that I think that if you correctly identified that that there's a privilege, and you correctly explained what the privilege is generally, like what the spousal privilege is, and how it applies to in this particular case, I think that you've gotten most of the points. Now that specific part, I really wish in these model answers it actually showed how they were graded, because I don't know if they really consider that like a critical thing that you're going to get lots of points for or not. And I kind of wish I could give you total clarity on it. But my gut feeling is that that's not really an essential part. That's a flourish, another element of or another aspect of privilege that that is relevant to this, and it's the best answer. But I don't think that that's the most important part of this question. So that's why I think that sometimes it's just about in these questions that say discuss, just throw it out. So now so now about this difference, about this distinction, and I wouldn't say write it if there's like no basis for it, but if you've got a spousal privilege and it tells you to discuss it, throw it in, because everything that you throw in gets points. And I think that it's important from a strategy perspective to look at the call of the question and kind of know the way that it's going to be graded, and you're going to be graded just kind of for the stuff that you throw out there. So, and then the other issue is about the timing of when the privilege was asserted. So that, I think, is, so you'd be getting, like, as you go through the rule, like you'd be getting points as you go. But I think that is probably more critical, like one of the more critical ones, because does it apply or not? Like the question is, can she testify or not? So before you go to what she can testify to, like, are there limits to the privilege? Can she testify or not? And if the if the timing of the assertion of the privilege makes a difference about whether she can testify or not, that's something that is like on a higher level than what she can testify about, if that makes sense.
And I think that's what kind of confused me about this question, because rarely do you see something that they seem to overlap to me. The first question and the second question, about her allowed to testify and what she can testify to, it was just seemed to overlap a little bit. So, but what you're saying is they really are asking different questions.
Yeah, they are, and I don't think so. So I think that question 2 is really dealing with the substance of what she's talking about, rather than, and I'll grant you, actually, like, I mean, now that you're saying that you read it the way that you read it, I think that could be actually confusing. Like, I wonder if this is do you know if this is a real question or a question that was written in like a study guide?
So this would have been, since it's Fleming's, this would have been a baby bar question.
So, for what it's worth,
Or bar.
No, it's a bar.
No, it'd be a bar, yeah, this would have been a
so
bar
this is a
question.
real bar question. It's
Yeah.
not something that a study guide wrote.
No.
So, I mean, for what it's worth, I think it's a poorly written question, but what are you gonna do? I mean, if you get something like that, you get something like that. But yeah, so, and not to repeat myself again and again and again, but if you're thinking about it in terms of layers of rules, your top level rule is, can it come in or not? Because if it can't come in, we're done. Who cares? But if it can't come in, what comes in? Like, what are you allowed to say? Can all of it come in, or only some of it come in? And how do you know? And which and what? And then once you've laid that out, what facts in this question address what you've said needs to be addressed in order to meet or not meet the rule? And I think that in terms of in terms of levels of rules, I think that this does a good job. What I would point out though is that I don't think you could write a good answer to this question if you didn't, I'm talking about question 2, if you didn't start always with relevance. And don't forget that, because if you have an evidence question, always come back to relevance. And that's the thing. I don't wanna go off on one of my famous tangents, but I'm working on a case right now, a criminal case. And in the trial, every objection practically is about the relevance of the evidence, and a lot of those objections are just because they're trying to keep out the really damning stuff. But you always need to start with whether it's relevant, because if it's not relevant, it's not coming in at all. Now, then the personal knowledge, when we start talking about personal knowledge, so now we're already going not to whether it's relevant, but the reliability. Is she able to testify to the stuff that she's testifying about? So talking about hierarchies, is it relevant, and then is it reliable? And then we've got all sorts of different rules about what makes evidence reliable. We've got hearsay rules, which are like a ton. We've got all these rules, but the hearsay rule is the rule in certain instances about whether we consider certain testimonial evidence reliable, because that's the way they did it in 17th century England, and now we're stuck with hearsay rules. But the hierarchy, I'm saying it for a third time, but the hierarchy is going to be whether it's evidence. So am I in the federal or the California rules of evidence? Are we talking about evidence? I could be talking about there could be a criminal law question that talks to you about whether they've proved the offense or not, right? So that the prosecutor, so you could have a criminal law question that's going to be something like, Bob walked into a property that wasn't his at night and stole a computer. Stealing a computer is a felony in the state of California. If the prosecution proves all these facts, have they proved that the defendant committed the crime of burglary? So that's not an evidence question, and I know that sounds like obvious, but if you want to put categories of things in your mind, so if I have a question like that, like the one that I gave you, and a lot of these questions are going to combine. So question 1 might be an element question, and question 2 might be an evidence question. But you want to be aware that in a question like the one that I just gave you, what we care about are the elements of burglary, and not if. Depending on how the question was written. So let's say that it throws in John was convicted on the basis of I'm trying to think of something that's clearly, obviously inadmissible. Bob was, the defendant was convicted based on evidence that was that there'll be something in the question where it's clear that the evidence isn't going to be admissible. Like maybe it's testimony that's hearsay, or maybe it's like a blind witness, or maybe it was evidence that was violative of the Fourth Amendment. Like there might be a question that has a fact in there that that really deals with the admissibility of the evidence. But if the call of the question asks you something like, did the prosecution prove its case we're not talking about the admissibility of the evidence or not. We're gonna go straight to the elements of whatever the offense is. So in my example, burglary, and, so start in the evidence box that we know that we're talking about evidence. And so if we're talking about evidence, it's gotta be relevant, and then it's gotta be reliable. And it's always gonna come down to relevance or reliability. Did we talk about Old Chief in here? The answer is always Old Chief. The answer is always Old Chief, and because any question about evidence always comes down to relevance and reliability in some shape or form. That's evidence. So is there another? So just for fun, right? Go through. Let's just someone talk me through these three witnesses, whether Whitney's testimony was admissible, whether Ella's testimony was admissible, or whether Fred's testimony was admissible. I mean, well, let's start with Ella, because we've talked about Whitney. Let's start with Ella. If someone just wants to talk me through it.
Okay, so if we're starting with relevance, the professors taught us to start with the whole evidence sandwich, whatever.
Yeah.
Logical, all the way through the middle portions and ending with like the legal relevance, whether it's like 403, whatever, California. So her test, if you could argue that her testimony is relevant to show that what she observed was that he was in the bushes waiting to kill what's her name, Vicky. That's why he had money. So what she observed is relevant.
Relevant because in some way, shape, or form, it makes it more likely than not that a fact that that a pertinent fact didn't happen.
So I don't know why they put legal relevance right after that, because that's kind of like the concluding portion, like whether it's ultimately admitted. So I kind of like place that at the end. So
by the way, like if I were to take a guess about why they did it that way, is because some professor or some bar examiner told them that the rule always has to be before the explanation. Oh, whether no matter what, the rule has to be before the explanation. And so that's why what I was saying a few weeks ago, maybe this redeems me. If you're a slave to the format, like a total slave to the format, you might end up with something like this, where you read it and you say, well, why are we talking about this here? And I used to be a staff attorney at the United States Court of Appeals, and our bench memos are structured in a way I have to present facts in the order that the district court judge learned about it. So you start with the complaint, and I can't start with what happened with Bob and Sue, because the court didn't know that. All the court knew is that the complaint was filed. And so that was the way I had to write the bench memos. And I was just like, there was no exception to that rule. But sometimes you end up with a memo that's, not as well written. So I agree with you, but the reason to do it that way is so that all the rules are in one place where the bar examiner can identify it, and you can get your boom 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 points. But I don't think that that's the best writing. And also give the bar examiner a break. They've read 1,000 of these, and most of them are terrible. Write an essay that's cogent and easy to read. So, but go on.
Yeah, and then so I would have transitioned us to the discussing reliability, which is here's personal knowledge is what the heading. So I would argue that her testimony is reliable because she had personal knowledge that by observing his muddy shoes or boots, and this therefore her testimony is reliable. And then of course moving on to the spousal privileges, dividing it between communication and testimonial. They've already ruled out communications privilege because they said this was not a communication between the spouses, it was an observation, so this privilege would not apply. But the testimonial privilege.
Okay, so slow down, because the one thing that you're not doing that and you probably wrote it this way, but so what's the rule first? Like in every case, like what's the rule first?
I thought we moved forward because we already went to discussion. One second.
Right, no, but yeah, okay, so I don't think I phrased that right. I don't mean like recite the rule. Yeah, we recited the rule.
Right.
But when you go through your analysis, every fact that you're talking about, I should know like how it gets you to the rule. So
Okay.
when I say discuss the rule first, I mean I don't think that was like really artful. But before I get to the little sub conclusions, before you get to the little sub conclusions, how does it apply? Like how does it fit with the rule? Does that make sense?
Yeah.
Okay, cool.
So spousal communication is any communication made during the time of marriage is protected, and despite them being married or not at the time of the testimony. So at this time, the communication. Well, I would rule that out. Just really, I would just go down to the point that this was not a communication. It was an observation. So therefore, this privilege would not apply because it's not communication. So, and moving forward with spousal testimony privilege, it is a privilege that would apply if the spouses were married at the time of the testimony. So at this time, I discussed in my essay that at this time, although what's her name? Vicky stated that they were separated, it does not.
Wait,
Whitney, Vicky's the dead one. Yeah, although Whitney stated that they are separated, it does not state that they are legal divorced. So they are still at the married state. So she would still be able to use her spousal testimonial privilege at this point. So I mean, I conclude that her testimony will be excluded despite the judge stating that she had to testify.
Yeah, I mean that's good, and that's why I think sometimes there might be a benefit to talking through it. Did I tell you one of the things that it says in this book, which I thought was kind of comical, but it says something like, a lot of people get isolated from their friends and family when studying for the bar. You should study by explaining these rules to your friends and family. This way you're studying and spending time with them. And which I thought was really funny, but there is a little grain of truth to that, which is that talking through the rule is going to help you understand it. Write stuff out. I mean, I know that at this stage of your lives, you probably how to study and learn, and you don't really want to be told and babied, but there's something that happens the way our brains are wired when we write something down as opposed to clack, clack, clack. I think it goes into the brain in a better way, in a different way. So just write some of this stuff out, or talk it out, or or use the ways that you can kind of get your brain to think about it in the best way possible. So we have, so we've got 40 minutes left, and one of these questions I really even think I did with you guys, right? Did we
Yeah, we
do?
did the SIP Pro one.
Yeah, we
Yeah.
did the Cipro one already. So what,
I'm sorry, I have to leave at 2:30 because that's good work.
that's fine, because I think it's fine anyway, but I think we're probably just a few minutes from being done, but you
Oh, no,
could-
I know, I
yeah,
just wanna let you know.
yeah, but so we went through the Cipro one. What can I do? Is there anything that you want to go over? And don't be shy, even if it's the Cipro one. But
The only one that it's still on the evidence one, I wasn't sure if it's so simple that I'm overthinking it, and that's why I think I don't get it, but the party opposing admission is just literally, evidence will be admissible because it's a statement made by the party opposing.
yeah, so basically, as a general rule, I can't testify about like what I heard someone say, except all these rules, right? So one of those rules is if the thing that I heard was said by one of the parties. And the reason for that is that like that's what we're here to kind of ascertain. And the party has plenty of ways to prove their case. I mean, they're the party. So that's don't overthink it. And I will tell you honestly, I had the same problem when I was in law school. I really did. It didn't make sense to me until I realized that it was very simple.
Okay, thank you.
Conspirator statements are admissible, right? You've done that. That actually happened in the case that I'm working on right now. So conspirator statements are admissible. All right, what else can I?
Actually, can you explain that a little more for me? I still don't.
Conspirator statements?
Yeah, I don't really understand what.
Okay, so I'm gonna say this is actually the real example from the real case that I'm working on. So the case is about synthetic cannabinoids that were for sale, and so an agent is surveilling the defendant, and she sees the defendant make a delivery of these she sees him deliver a box to a gas station, and so she waits and she goes into the gas station and she begins to, and she's testifying. So now we're in court, right? She's testifying about what happened that day. So I surveilled him, I watched him make the delivery to the gas station. I walked into the gas station and I asked the clerk, hey, what are those things? Objection, hearsay. Then the response to the objection, conspirator statement. What does that mean? So arguably, if the gas station attendant was selling the illegal substance, he's part of the conspiracy to sell the illegal substance. So anything that he said is admissible as a conspirator. It would not be left out as hearsay. Make sense?
Does he have to be charged? I'm sorry.
How would he be a conspirator? For a conspirator, you need an agreement.
Right. So you're probably not. So you're probably. I don't mean to like be. I hope it's not confusing, but that's just the way it's practically going to go down. Now, whether he could be charged with conspiracy is a separate question, but for purposes of the rules of evidence, he was part of this.
Transaction.
So
And does he have to be charged with that as well, or charged with any element of the crime? Or-
no, and in fact, the gas station attendant was not charged.
Oh, okay,
Yeah.
so that's interesting.
Yeah, my client is
Well,
in
how-
jail for 240 months.
So
So
how, if he's not, okay, so you're saying you can use a co-conspirator, rule for hearsay, but if he's not charged, how does that, doesn't add up to me?
I'm not trying to be political, but it's the same way that you can commit obstruction of justice even if you haven't actually committed an offense allegedly. But
Yeah, you can.
I'm talking about the Mueller investigation, and to me, it doesn't make it, so so to me, and I'm not being political, I have no opinion one way or the other for purposes of this class, but to me, logically, it doesn't make sense that you can be guilty of obstruction of justice if there was no offense, if there was no initial offense. How can I obstruct the investigation into something that wasn't a crime? I mean, to me, that doesn't make sense, but I know that's not really what you're talking about, and that's just like I mean, I hate to say that's just the way it is, but that's kind of just the way it is.
So he just has to be an accused co-conspirator.
Yeah.
Okay.
He has to be part of whatever the illegal act is going to be, and it makes a big difference who your judge is, whether they admit it or not, which is why you make the objection, right? Because the judge might agree with you, and when you appeal an evidentiary ruling, what's the standard of review? Do you know? Abuse of discretion. So, if I let it in, can you really say I've abused my discretion? Probably not, right? But if I exclude it, can you say that I abuse my discretion? Probably not. So, swear this is true. When I was in evidence, the example that we got with abuse of discretion was that if you work for the university and the university's biggest donor is taking you, like you're supposed to take him out to dinner, and the university gives you like a huge budget to to go to dinner, but you can go anywhere you want. If you take him to a strip club, you've obviously abused your discretion by spending like all this money at the strip club. But if you take him to Hooters, it might be a closer call of whether you abuse your discretion or not, because like you took him, it's still a restaurant, and if you took him to an actual restaurant, then it's really clear that you haven't abused your discretion. So abusive. So the standard of review is something that even though appellate law is not going to be on the bar, understanding the standard of review can sometimes help you understand how evidence works, because how is it going to be reviewed by the higher court? So okay, what else? All right, are we calling it a day? Half an hour early? Yeah? No? I mean, I'm here for you guys, so. You're good? Okay,
That's good, thank you.
thank you.
So what are you hoping is gonna be on the bar?
What do I
What are your
hope?
strong subjects?
I mean, Civ Pro, but other than that, I don't, other than that, it's all, either stuff I don't